Utilizing cloud computing, social media, and even running a completely firm brings about its own set of cybersecurity concerns that you need to be aware of. Now, while some laws do require that you advise clients who are affected by a data breach, there is no requirement to advise clients who are not affected. So this is something to keep in mind. Now, the Model Ethics 2020 rules that were adopted by the ABA in 2012 explicitly require that lawyers provide competent representation, which includes benefits and risks associated with the use of relevant technology. And this is Rule 1.1. Rule 1.6 also requires that you make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to info relating to the representation of a client. Now, because information security is becoming a legal obligation, it's important to understand that the law views security as a relative concept. So the standard for compliance is typically that security must be reasonable or appropriate. So rarely is there going to be any legislation that specifically lists out security measures you have to take. Generally, security measures that a business implements must respond to the particular threats it faces and its specific vulnerabilities. So much like the traditional negligence law standard of care, which depends upon circumstances of the case and the extent of foreseeable danger, security regulations are taking the same approach. So there may not be any safe harbors for security. In other words, you've got to take this seriously. Cloud computing, the important thing to remember here is that the legal obligation to provide security of your data still remains with your business. So you're going to have to manage this risk as well. You're going to have to exercise due diligence in selecting your service provider and then contractually require that they implement appropriate security measures. And then most importantly, you've got to remember to monitor their performance. It's not a set it and forget it type thing. It's going to require that your firm constantly monitor what's going on. Now, the Maine Board of Overseers of the Bar, in Opinion 207 in 2013, had some suggestions when using cloud computing services. And they suggest that you make sure the service explicitly agrees that it has no ownership or security interest in the data, that it has an enforceable obligation to preserve security, that it will notify the lawyer if requested to produce data to a third party, and then provide that lawyer with the ability to respond to the request before the provider produces the requested info. That it has technology built to withstand a reasonably foreseeable attempt to infiltrate data, which includes the use of penetration testing. That it provides the firm with the right to audit their security procedures and to obtain copies of any security audits performed. That they're going to host the firm's data only within a specified geographic area. So remember, if that's hosted outside the U.S., it's up to you to determine that the hosting jurisdiction has privacy laws, data security laws, and protection against unlawful search and seizure that's at least as rigorous as that's found here in the U.S. And finally, you want to make sure that it provides the ability for your law firm on demand to get data from their servers for your firm's own use or for in-house backup. Now, in addition to this, you should also know how data can be retrieved if your provider goes out of business or its services get interrupted. Ignorance of how this technology works is not going to be an excuse, so if you don't know, you need to make sure that you contact somebody who does so that way you can understand. When it comes to social media, there's the risk of disclosure of seemingly innocuous information that may lead to disclosure of confidential client information. For instance, if you're posting a query to other lawyers online about a particular procedural problem maybe that you're having in a pending case, you could be in violation of confidentiality under Rule 1.6 if it's too close to the actual case so that the facts can be matched to a specific individual or company. The information is not already generally known, and the disclosure may prejudice or embarrass the client. In addition, supervision of other lawyers and non-lawyers includes the duty to educate them about how this confidentiality obligation applies to them on Facebook and casual comments they may make on LinkedIn or similar platforms. Specifically, Rules 5.1 and 5.3 may require your firm to have internal policies designed to protect client confidence within this context. Now, running a law firm, it's going to be cost-effective to allow your employees to use their own devices. Just understand that vulnerabilities in design and configuration of the device, malware that's in the apps, interception of unencrypted data, and things like this are going to put you at odds here. So make sure that you use mobile device management, which allows you to centrally and remotely lock or erase the mobile devices, or check their geographic location in the case that it's lost or stolen. Only allow known users and devices on your network. Don't allow jailbroken or rooted phones. Data should always be encrypted. That way, if there's ever a data breach, the data itself is still secure. So in conclusion, make sure you develop a comprehensive information security plan and you conduct a risk assessment. Use appropriate encryption technology to ensure your law firm's sensitive data. Use mobile device management where possible. Only allow known users and devices to access your network. Develop data retention and destruction plans. Engage in pre-event liaison planning with your ISP and local law enforcement so you know where to go if a data breach does occur and so that they know who you are. And then make sure you have people in your office who are briefed on the issues and implications related to these breaches so they aren't forced to think through them for the first time in the middle of a breach.